Hi there. Daniel Kirsch again here, and want to complete our lecture on civil liberties and pick up where we left off. I was talking quite at length, I guess, about selective incorporation, so let me start again there. Selective incorporation means the Bill of Rights applies to the states and not just to the federal government. So what that means is all of those rights that are in the Bill of Rights, the freedom of speech, freedom to exercise your own religion, freedom from unreasonable search and seizure, all of those things, and freedom from cruel and unusual punishment, as noted prominently from the kind of English Bill of Rights and carried over to the U.S. Bill of Rights. All of that to say that selective incorporation means that the Bill of Rights doesn't uniformly apply to all of those rights, even though the same legal principle applies in every single case. There are roughly, in the 10 amendments to the Constitution, there are, I think 37, I saw listed once, 37 or 38 distinct rights within the Bill of Rights. And for it to have federal protection, for you to have U.S. constitutional protection against the states or local governments, also, trampling on your rights, freedom from those things, you need to make sure that your right that you're being protected in has already seen a Supreme Court case. So even though every single case is the same, where, as I was trying to express last time, even though every case is the same, it means that all the rights in the Bill of Rights don't apply to the states until the Supreme Court clarifies that this particular right applies to the states. So, so it's kind of, I was just saying that it was silly because it really is a waste of time, and it is unclear for, I guess you could probably say, political reasons. But for the most part, there doesn't seem to be any clear political motive behind making sure that the states don't also have to apply the Bill of Rights. Even though most of the states have constitutions really that are far more rights-oriented than most of the U.S. Bill of Rights are. So that's what selective incorporation is. So the reason I kind of brought that up is because there are 3 areas of law that I think are good examples that I know something about that I want to cover today. And those 3 areas of civil liberties law are privacy, speech, and religion. Privacy, speech, and religion. So privacy is, let me tell you a quick story. It's not written into the Constitution. It is and it isn't. The word privacy is nowhere in the Constitution. Let's be clear about that. The right to privacy is seen by most modern constitutional scholars as something that is heavily implied within the Constitution, and to take it a step further, most of those scholars who agree that there is a right to privacy also agree that it needs to be raised to an explicit level so that rights that also follow from the right to privacy can be safeguarded just as vigorously by the Constitution. So to start off with, as far as which rights constitute the right to privacy, if you read throughout, I had the other day when I was recording this before, I had a list of the rights, but I'll have to do it by heart. In amendments, I think 3, 4, 5, and 9, and 10. And it's supposed to be under the penumbra of the First Amendment, whatever that really means. But sort of the umbrella of the First Amendment, that it's the right of people to assemble and have freedom of speech. Those are just kind of the fundamental rights. The reason there's a reason why the First Amendment is the first listed amendment. But within that right, more specifically, the Third Amendment talks about the right against quartering soldiers in someone's home or their house. And so right there, the word house, and kind of synonymous with home, is starting to create a zone of somehow private protection. The Fourth Amendment is probably the most powerful one against unreasonable search and seizure of your persons or property. So really, maybe all you need is the Fourth Amendment, because it's no unwarranted search, or if not search, kind of policy. So any kind of legal arm of the executive branch is kind of reaching out to, to affect anyone's person. That's in the Fourth Amendment. The Fifth Amendment is the right against self-incrimination. And so you've heard about it in Miranda rights, and we're not going to be covering Miranda rights today. But if you've seen a TV show involving police or movie, you know what the Miranda rights are. And the right to remain silent is the first one, so that you don't, because you have a constitutional right not to testify against yourself. The Ninth Amendment and the 10th Amendment are very similar. They're essentially any rights that aren't listed here are still rights. So that's the case, really, for the right to privacy. And you may think that that's thin, but that's ultimately what it fundamentally rests on. But if you think it's reasonable, then we have a right to privacy. And so when this was first articulated was a case wherein there was a law passed by the state of Connecticut that there was not to be any use or possession of birth control methods. For example, like condoms. You couldn't buy them in a drugstore and you couldn't distribute them. There was an organization that had been founded, I think more than 40 years before, called Planned Parenthood. And Planned Parenthood, the division head was, I believe, named Karen Griswold. And she decided that she and her local branch of Planned Parenthood decided they were going to openly break this law in order to be arrested and test the argument in front of, hopefully, the Supreme Court. And it did take a while, but she was able to get to the Supreme Court after being arrested for distributing condoms, essentially, in Connecticut. And the argument they made, and that the court adopted, really, was that how would you ever enforce such a law that you couldn't use, even married couples couldn't use contraception, and so the image that was planted in the minds of the judges and the justices, rather, that made it into the text of the opinion is, are we supposed to have police kind of going through people's sock drawers and their dressers in their homes when they're a married couple to make sure that they're not using birth control? Or worse, are they supposed to be observing people in intimacy? So, neither of those things is desirable, even if you had reasonable assurance that somehow they were breaking the law. That's not a good enough reason to break people's right to privacy. Or, maybe it's just, they're just clarifying what unreasonable search and seizure is. So in any event, the right to privacy is basically articulated first in that case in the Supreme Court in a legally binding way in Griswold versus Connecticut in 1961. And one thing that I mentioned when this video cut off before, but that I'm putting in the links, I've already put in the links to Canvas, is that the recent confirmation hearings for the, as of this recording, as yet unconfirmed justice appointee Amy Coney Barrett, she was quizzed extensively on the right to privacy, not only because of its just inherent kind of legal value, but also because of its political implications. Because there's two more cases I want to mention. After Griswold, it took about 12 years for an abortion rights case, reproductive rights case, to make it to the Supreme Court. And at the time, there were many, many laws on the books in many states about the um, the right to an abortion. And there were not a lot of states where it was outright banned, but there were plenty of states where there were laws on the books, notably Texas. And so in this case, in Texas, Nora McCorvey, we later learned, but at the time she was called Jane Roe, to keep her anonymity. She wanted an abortion, and the state Supreme Court had said that she can't have one because there's a law in the books in Texas, and we recognize the laws of the state of Texas that we think are germane to and compatible with, the U.S. Constitution. But the Supreme Court didn't see it that way. They had a core holding, and I won't get into the specifics of the holding, but their core holding was that because there is a right to privacy and a right to sort of self-determination within one's own body, then there is not enough of a good reason to ban abortion, at least in the first part of pregnancy. So it immediately, the reason why it was such a big decision at the time was because they introduced a framework according to the trimester system, and that framework did not exist in any laws that were on the books at the time in any states. And so all of these laws, much like what happened with the death penalty about 5 years later, because it didn't have the same considerations for appeals, I suppose. Because of all of this, all of those laws were thrown out. They were declared unconstitutional. So a lot of state laws immediately after Roe versus Wade were declared unconstitutional. And so abortion was effectively not restricted for, I want to say, a very brief time, maybe about 10 years, until it began. There was a more organized campaign to systematically, effectively ban abortion in many states, and even shut down many Planned Parenthood sponsored clinics. And so, anyway, Roe versus Wade is probably at this point, if it's going to be revisited, both Roe versus Wade and possibly Griswold versus Connecticut could be revisited in a substantive way in terms of the question of whether the right to privacy is real, and whether the reproductive rights that follow from the right to privacy are also real. And if those things, and if the court decides they are not, then we have a whole new ballgame at the federal and state level. And so if there's no more right to privacy, then another decision is thrown out, and that decision was Obergefell versus Hodges. And that decision, I'm sorry, no, that was later. That was sustaining the right to, I believe, same-sex marriage. Lawrence versus Texas, also another Texas law. And this law was actually an anti-sodomy law, and sodomy is just a non. Sodomy is just sex, and but it's between people that it's not, but it's any other form of sex besides sexual intercourse. And so so basically all of these laws across the country were these anti-sodomy laws, and I think maybe 40 states as of 2003 were thrown out because there was a case where two men were in the privacy of their own home, involved in a sexual relationship, and some neighbors actually called the police on them and had them arrested. And so they were arrested and sent to jail for a couple of days at least, and out on probation very quickly. But they appealed their case to the Supreme Court, and they won because they cited Roe versus Wade and Griswold versus Connecticut as their precedents. And so because at that point all these anti-sodomy laws were thrown out, there was no longer any sort of discrimination about who can engage in sexual relationships, and and uh, and so the kind of pathway was clear for same-sex marriage. And the person who wrote both that same-sex marriage decision and Lawrence versus Texas was Sacramento's Anthony Kennedy, who just retired a few years ago. So that is the right to privacy in a very quick nutshell. The freedom of speech was never really tested until World War One, at least in a political way. When you think of, and hang on, if you'll permit me, I'm just gonna look behind the camera right now and make sure that we're still recording. Yes. So, freedom of speech is fairly straightforward. Congress shall make no law abridging a freedom of speech. And that wasn't really tested until World War One, when there was a lot of dissent by a lot of labor groups and a lot of really left-wing and socialist groups that had membership of people who were drafted and being drafted, and those kind of young working-class men. They were, assembling into these kind of dissenting groups, and they were saying all kinds of things about the reason why you shouldn't get involved in the war. In other words, why you shouldn't join up with the military, and also if you should resist the draft. So one of these cases reached the Supreme Court. It was called Shank versus U.S., and it was a violation of a law that was written in response to these dissenting groups. And the laws were the Espionage Act and the Sedition Act. And the Sedition Act was just an act that meant if you say something seditious against the United States, treasonous against the United States, and seek to undermine the U.S. war effort, you are subject to prosecution. And so one of the dissenting groups had decided that they really wanted to make an impact, and they wanted to prevent their constituency from being drafted, and also make a political point. So what they did is they got a list of draft age young men, and they sent a mailer to all these young men, and the mailer said, it's your right to not be drafted. It's against the 13th Amendment, which, as you recall from earlier in the first video, is a ban on slavery. They said you're essentially enslaved when you're conscripted. So they said, look, you just assert your right constitutionally. You are not supposed to be drafted, and so you shouldn't be drafted, and resist it. It's fine. It's legal. The Supreme Court, represented by the person writing the decision, Justice Oliver Wendell Holmes, Jr., said, look, you can't falsely shout fire in a crowded theater. And yes, that is where the phrase comes from. You can't create a panic out of information that is wrong and that you know to be wrong. So the case had been made that these people were kind of spreading falsehoods, and in doing so, they were creating a panic, or in other words, they were creating a form of violence that is a harm against the United States and the war effort by kind of weakening the ability of people to be conscripted and of the U.S. government to recruit soldiers. So because of this, he said you can't falsely shout fire in a crowded theater. These people and their mailer represents a clear and present danger to the United States. And so that does not fall under the protection of the First Amendment. The second about 2 years later, there's another case, Abrams versus the United States. And there were some people who decided to, again, another left-wing group, a different one, passed out flyers in front of a weapons factory in the U.S. and said, all you workers who are making weapons, you should join us and you should oppose the war. And, it doesn't really make sense to ask people who are working in a weapons factory to oppose a war. It's kind of their business. Um, so it's where their income comes from. So it doesn't seem like they'd be very effective. So the court, kind of echoing what Holmes wrote 2 years before, said, "Oh, well, these people represent a clear and present danger, so they don't have the protection of the First Amendment." And Holmes said, "Hold on, I wrote that, and that's not what I meant. Uh, what I wrote is that if somebody presents a clear and present danger to the U.S., these people do not present a clear and present danger to the U.S. because they have absolutely no hope of succeeding. Um, they are poor and puny anonymities. They are nameless people who are nothing more than an annoyance. But this is not an effective tactic or strategy, and so there's no reason why we have to restrict them. So therefore, they have the protection of the First Amendment." But he was a dissenting voice, and ultimately the court decided to let those people stay in prison. But there was another judge, I should say, who was not in the court, and his name was Learned Hand. And I won't write that out; it takes too long. But Learned Hand was a federal judge in New York, and he had a completely different way of interpreting the First Amendment. He said, if you express words that are the words themselves clearly show that you are intending to cause violence, to break the law, to undermine the security of the United States, according to this one law that's been passed, those words are what get you in trouble. The words themselves shouldn't be protected if you can show that the words, in whatever context, are meant to cause violence. And so those don't have the protection. Those words themselves don't have the protection of the First Amendment. And Holmes thought it was all about context, and Hand thought, no, that's not scientific at all, because people can manipulate context, but they can't manipulate words. They're black and white on the page. And so it's content that he cared about. And he wrote to Holmes and said this. Holmes didn't understand the difference between the two decisions. And so it wasn't until 1969, I believe, that another case, Brandenburg versus Ohio, came to the court. And in that case, the Ku Klux Klan was on local TV saying all kinds of terrible Ku Klux Klan-like things, and that they want to, cause violence to this group and that group, and saying all kinds of words that were very insulting to people. And in no case, the court asked, did they say anything specific? Did they want to kill a single person or hurt a single person? And just a vague group of people, open to interpretation. Not vague, but still open to interpretation in a legal sense. And then also, they didn't say a specific instance of wanting to kill anyone or hurt anyone. So because of that, they said it lacked context and content. And so because of that, that's the real test if you apply both tests, and said unless there is an immediate incitement to violence, that I want to go and rob this bank right now today, and here's the keys, and so please help me do that. Unless you have that, you can't restrict their speech. So if you want to say instead, I feel like I want to rob banks, you can say that. Or I feel like I might want to rob, several banks, or in these particular banks. That's fine. But if you say that I want to, if you go outside of a bank and you have, here I have the security guard's keys, do with them what you will. Holmes would restrict that kind of speech. But Hand would not, because they're not saying go rob the bank. So robbing a bank is my analogy there. You have to have both the immediate immediacy and the incitement to violence for it to be restricted speech. All other speech is restricted, is permitted, I should say. So immediate incitement is actually a very liberal interpretation of freedom of speech. Everything except an immediate incitement to violence is really allowed. Finally, in religion, I want to say this really, really quickly, actually. There are two clauses about religion in the First Amendment, and they're right next to each other. That Congress shall make no law abridging the freedom to exercise religion, respecting the establishment of religion, or or restricting the free exercise thereof. So what that means is an establishment of religion means something like the Church of England, that it's an agency of the government. You pay taxes, and the taxes go to fund the church, and everyone is supposed to go to that church. The U.S. doesn't have that, and when it was written, the Bill of Rights didn't apply to the states, and so there were even places in like the state of Virginia was talking about maybe establishing a Church of Virginia. Didn't happen, but still there was talk, and at this point though, there's not so much the question of whether there's an established church, but whether the U.S. should be contributing money towards religious organizations that constitute effectively an establishment of religion. And so this is what's open to interpretation. And the reason why it even happens is because there have been a series of cases about mostly private religious schools, that for various reasons, and I'll let you kind of read about this on your own. I'll wrap this up. But for various reasons, these schools have said, look, we're schools, we need money, and we have non-religious functions. Why shouldn't our students also benefit from the same funds that public school students do? But the counter-argument, of course, is, well, if you give money to these religious organizations for secular purposes or religious purposes, or secular purposes or educational purposes, they're going to use the money they already have for religious purposes. So you're sort of indirectly but very materially helping out these religions. And sometimes now, because most of these distinctions have been abolished, now you just have outright, tax monies going directly to church organizations that are supposed to use them for schools. Indiana is an example of that, and I provided a link to the NPR story that I would urge you to listen to from 2016. So that's that as far as religion. Oh, and I'm sorry, just to put a bow on this. So because you don't want to create hostility towards religion, the reason you don't want to create hostility, for example, there's religious organizations are tax exempt, and in one of the verse cases there was an argument about tax exemption, and then also public school buses should be able to pick up private school children and drop them off at private schools. So that kind of was the start of the slippery slope, if you will. So at that point, now we're talking about not just encouraging free exercise, but we're openly going past just free exercise to an area where where a lot of people think, at least, where we're establishing religion. So that's really the controversy. So I would urge you to listen to that story about Indiana Governor Mike Pence and that policy in 2016. And that's all I have for now. And I hope this was helpful and it closed out the lecture. Thanks so much, and thanks for watching, and I'll talk to you in class.